Okay, can you all hear me?
Yes, Judge.
That's better. I think that it's
That's
gone.
better.
All right, now we just gotta wait for Mr. Gore to
There
come
he
back.
is.
Okay. All righty. This is case number 18-00971801. People of the state of Michigan versus Mr. Paul Gorey. And we are here. What are we here for? We were continuing an evidentiary hearing. Well, it wasn't yet decided whether Mr. Gorey was going to testify or we were going to leave it with the testimony of the officer. The officer had finished testifying. The court did take notes from the officer's testimony. The court has also looked at the briefs filed by the parties. Then the court received a motion in order placing defendant on diversion, which the court signed. And so I thought the matter was concluded. And then I received some information about maybe not. So can you tell the court what's going on at this point?
Your Honor, on behalf of Mr. Gorey, when I spoke to him, he said he wanted the case dismissed, which would require proceeding. And we talked about the diversion, and he had some issues about the diversion, and he was concerned about getting the money that he had back, $554. And so he had some other issues, and he said he wanted to address the court. So I was going to allow him to come and do that. I don't know whether he wants to do that as part of the evidentiary hearing or whether he wanted to address the court separately. I mean, I could let him do it through the evidentiary hearing in terms of what he wants to tell the court about what happened. I don't know. He at one point we discussed the diversion, and then he indicated he wanted to come back to court and get more information about the case. He really wanted the case dismissed.
Okay, so Ms. McCrae, put your appearance on the record.
Good afternoon, Your Honor. Prosecutor Andrea McCrae, P number 83698.
All right, and court would know for the record that Ms. McCrae was on the call at the time that Mr. Mencken was speaking regarding this case, and Mr. Gorey is on the line too. Mr. Gorey, can you state your name for the record?
Paul Gorey.
Okay, good. All right, so where we are now is, I guess, Mr. Gorey, your attorney wants to know what you want to do. We had already concluded the hearing with respect to the officer. The court was going to rule after hearing the testimony of the officer as well as reading the brief and you give us some case law. What do you want to do? Or are you going into diversion?
Do you want this on record, ma'am? Because it's already been an embarrassment and it's been a travesty. It's been ridiculous how they've made a mockery out of the court system. And I just want justice. So if you can adjust it on the side, we can go sidebar. But my rights have been violated, and that young man got on stand and committed perjury.
Okay, well, Mr. Gorey, the court hasn't made any decisions yet. Right now, I just want to know, are you taking the oath and testifying at this evidentiary hearing, or do you just want the court to speak to the attorneys separately? What do you, because my understanding is the officer has already testified. I will make my decision based on that. Do you want to testify, or do you want the court to just proceed?
Well, I just want the court to know that my rights have been violated as far as my constitutional rights, my civil rights.
Mr. Gore, you said that numerous times. The question is, are you going to testify in this evidentiary hearing, or are you going to leave it to your attorney to speak on your behalf regarding how your rights were violated at this stop?
I mean, I can testify my own. I can tell you exactly what happened. I was there. I can recall just like it was yesterday. I can tell you exactly what happened from the rooter to the tutor. And then, like you said, you're fair. I want you to determine what should be done.
So that's my question. Are you testifying at this evidentiary hearing, or are you just letting
Yes.
your attorney? Okay.
Yes,
Well,
I'm
let's go.
testifying.
All right, let's go then. All right.
Okay.
Mr. Gorey, let me have you raise your right hand. Well, let me let the clerk swear you.
Okay. Mr. Gorey, I just need you to raise your right hand, please.
We have to be able to
Okay.
see you raise your right hand.
Can you see me?
Yeah, we see it now.
Okay.
Okay.
Mr. Gorey, do you promise the testimony you give today will be truthful?
Yes, sir.
Okay, go ahead, Mr. Mencken.
And Your Honor, I'm not sure if I wound up putting my name on the record, at least when we went back on. For the record, Steve Mencken, P31562, appearing on behalf of Paul Gorey.
Okay, go ahead. I believe you did, but go ahead.
Okay, all right. Mr. Gorey, why don't you state your name again for the record?
Paul Lamont Gorey.
Okay, and Gorey, you heard the testimony of the officer. Do you remember what happened last time as far as the testimony of Officer Esposito?
Yes, I do.
Okay, and can you tell me when you were involved in this traffic stop, and sorry, I got so much
Are you
paperwork here.
looking for the date, Mr. Mencken?
I got it here, I think. It was on it was June 29th of 2017. Do you recall what happened when there was a traffic stop?
Yes, I do.
Okay, and so at that particular time, were you driving or were you a passenger in the vehicle?
I was a passenger in the vehicle.
Okay, and so did there come a point in time when the vehicle was stopped by was stopped by somebody?
Yes.
Okay, and did you learn who was stopping the vehicle?
Yes.
And who was that?
It was a Dearborn Heights police car and an Inkster police car.
Okay, and do you remember if there were two officers in particular? I know Officer Esposito is the one that testified, and then he mentioned an Officer Stevens. Do you remember those two officers?
There was 4 officers.
Okay, so Officer Esposito indicated that he stopped when he stopped the vehicle, that he was involved with the driver of the vehicle, correct?
Correct.
Okay, and do you
First of all, excuse me, sir.
Wait, Mr. Gorey, hold on. Now let me explain the rules of this evidentiary hearing. You can only answer.
Okay, I know I have to wait, my miss. I understand that. I just wanted to tell him where the stop was at, though, where we were stopped at.
Oh, okay.
All right, well, let him clarify that. Go ahead, Mr. Mencken.
Okay. Well, since you brought it, where were you stopped?
We were stopped at a car wash with stadium lights in it.
Okay. And where were you stopped in that car wash?
Right as soon as we pulled in the parking lot, right off Michigan Ave.
Okay. And when you were stopped, did you continue to remain inside the vehicle?
Yes.
Or did you get out? Okay. And so did you see what happened from that position?
Yes, we was an escort. I've seen everything.
Mr. Mencken, did you freeze?
Hello?
Hold on, I think Mr. Mencken's device froze because he's in the same spot. Hold on a second, Mr. Gorey. Mr. Mencken, you might have to log off and log back on. Looks like his device froze.
Excuse me, Your Honor. I'm at work also, so I'm multitasking.
Okay, that's fine, Mr. Gore. Just make sure there's no background sounds. Your attorney logged off, so he's probably logging back on, okay?
Okay. No, the bell's going off there and the phone's ringing up front. That was it. That was you calling?
Mr. Gorey, you have to mute
Okay,
your
I'm in court,
device.
so what you need me to do?
Well, right now I got a vacuum on 203.
Oh, okay. Well, I can't do that now.
Yeah, I know.
All right, well.
11, 14, and 15 need toilet paper and towels.
Mr.
Okay.
Can you
Gorey,
do that? All right.
Yes.
you gotta mute
Yes,
your
Your
device.
Honor.
You're in court,
Uh-huh.
Mr. Gorey. You do not have background sound.
I know. I'm sorry, ma'am. I'm at work. I'm at work and at home at the same time. I'm on Michigan Ave as we speak.
Mr. Gorey, mute your device. You can still hear. Just mute your device so we cannot hear you.
Oh, okay. Okay.
I don't think it's muted yet.
Did that do it?
No, we can hear you. We can still hear you. You have to hit the mute button. All right, Mr. Minkin? No, you're muted, Mr. Minkin.
You need something?
Actually, yeah, I need to call it
What room you in?
37.
37?
Yes.
All right.
Can you hear me now?
Mr. Gorey. Yeah, I can. Mr. Gorey. Mr. Gorey, can you hear me?
Damn, dog. I'll bring it right to you.
No, I don't even think. Mr. Gorey. Mr. Gorey. I think he's muted it from his side. Mr.
there he is.
Gorey. I don't think he can hear me. Mr.
I think-
Gorey.
He probably thought he had trouble with his internet. I think it was mine.
Yeah, I think he hit the button though, and he can't. I think he's muted my voice. I told him to mute himself, and he's muted the court.
Okay.
Is there a way for you to text him or something?
Well, I'm using my phone. I'm not sure. I'm not sure if I can do both at the same time. I took off my internet wasn't working from my computer, and I took it and I'm using it through my phone because I think there was a problem with mine.
Mr. Gorey. Mr. Gorey. Mr. Gorey. I think he's
Okay.
muted the court.
Okay.
Or he's trying to reconnect. Mr. Gorey.
I'm gonna do it from my phone. I'm gonna leave my phone internet and come and call him. I'm connecting again from my computer. Let me see if I can
Okay.
get off this.
Yeah, you gotta tell him we can't conduct this hearing while he's walking around and working. He has to be still to answer these questions. There is no multitasking in court.
Okay. I'm back.
Mr. Gorey,
Yes.
we cannot have this hearing if you're walking around and talking to people. You have to be stationary. You are in court as if you were in this building.
I understand. I'm not gonna talk to no more. I'm just
you
working.
have to sit down and stop walking and pay attention to the questions that are being asked of you.
Okay, I got you. I'm ready. I was just waiting for Mr. Mickens to get back, miss.
Okay, he's back.
Okay.
So you can't have any more interruptions.
All right.
All right, let's go. Mr. Mickens, you're muted.
Okay, I got it unmuted and I'm back on my computer again. Okay.
All right, let's go.
All right. So let me just, so Mr. Gore, you said you were at a, was it a car wash that you were stopped?
Correct.
Okay. And at that particular time, so somebody that you learned was it the this Officer Esposito, was he the one that came up to the vehicle?
I'm not sure. One of them.
Okay. And then the officer, was there an officer that was talking to the driver?
Yes.
Okay. And do you recall if that was the officer that was testifying, or you couldn't tell because you couldn't see last time?
Well, actually, that was the one they processed me, and they pulled along the side of us. When they pulled, one pulled behind, the Inkster cop pulled behind us. Well, actually, they pulled behind us, and the Inkster cop pulled on the side. And they got out. They said, "Don't move." Then they told a man to get out the car, the white boy to get out the car. Naturally, black folks know not to move. We were taught that since we were children. So I don't know where they got that moving there.
Okay, well,
I was moving.
There's no question,
Okay.
Mr. Gore. You can't
Okay.
do a narrative.
Okay.
You have to ask a question.
Okay.
Okay. Well, yeah, that was it.
Please focus this evidentiary hearing for me, please, Mr. Mingus.
Okay.
Okay. So then the did the driver of the vehicle, did he get out with one of the officers?
Yes, he got out.
Okay. And did you overhear what the reason for why you were stopped?
He said we were pulled over for a license plate bulb initially.
Okay, that's all I want to know. Just answer my questions. Okay, so initially he came out. And do you know did you hear the conversation that he had with the driver?
Yes.
Okay. And do you recall whether the conversation, whether the driver had a valid driver's license?
Yes, he had a valid driver's license.
And do you
Everything
recall
on the car was valid.
And do you recall whether he was able to produce like his proof of insurance and that he owned the vehicle?
Everything was valid. I've been knowing that boy for years.
Hold on, Mr. Gore. Hold on. Just answer the question asked, okay?
Yes.
Oh.
He did. He had all his credentials. Everything was legit.
Okay. And so did there come a point?
Hold on. I don't want slang. So the driver had a valid driver's license. The driver had he had insurance as well?
Correct. He had everything, ma'am. Yes, ma'am.
And he had registration?
Yes, correct.
Okay, go ahead. He had everything. Okay.
Okay,
ahead,
so you heard the testimony. Was your understanding that you were stopped because his license plate wasn't lit up and they couldn't see it initially?
Yeah, that's what the initial stop was.
Okay.
It was no fault, no other faulty equipment.
Okay. So at that point, what happened with the driver?
He threw something.
Okay. Where did he throw something?
He threw something back in the car towards me.
Okay. And then did you see anything else?
No, I ain't see nothing else. I just think he just threw something.
Okay. Did there come a point in time where...
Wait, I have a question. Mr. Gore, where were you sitting in the car?
I'm sitting on the passenger side, ma'am. In the front seat, it's just us two.
Okay.
And it's a little tiny Escort.
So when you say the driver threw something, you mean he threw it over to where you were sitting?
Yes, ma'am. He threw something right in the middle, right where I was sitting. And I was in the process of putting a plate. When they said they were seeing me make motions, I was putting a plate of food that this lady had just cooked for me. God rest her soul. That's what I was putting on the floor.
Okay, so let me ask you that in a question. So, did there come a point in time where you did something with, you had said you had a plate in your hand?
Yes, sir. I had a plate of food, a plate of chicken, greens, macaroni and cheese, and I never got to eat it. I was mad. Mad about it.
And what did you do with that food?
I put it on the floor, and that's when because they told me to get out the car.
Okay. So when you did that, did you get out of the car?
Yep.
Okay. And then at that point, that's did they take anything from you?
They asked me would I allow them to search me, and I said yes. They asked me what did I have on me, and I said I had a bag of weed and my medication in my pill bottle in my right pocket.
Okay, and did you have a prescription for that?
Yes.
Okay, and they also indicated that they found some kind of was it cocaine or powder or something in the car? Where was that?
They told me that the next day, when I talked to the detective, I didn't see no substance until that next day, and it's on recording. It's all on recording.
Okay, so let me ask you this. At that particular time, did you have anything else other than what you just said you had on you, or that was brought into the car by you?
Yes.
What else did you have?
I had my book bag.
How come you're supposed to be sitting down? I'm
in a room. I'm just moving around. I'm sitting around. I ain't nobody in here with me. I'm in the storage room. But yes, I had my book bag with my medication in it, with my name on all the bottles that they claim that they got in the tag room.
Okay. All right. And then did you have any kind of cocaine on you or by you?
No, I never indulged in cocaine, never had a drop, never had no substance abuse, never had nothing. And I go to doctors quite frequently. They take my blood every month. Never been involved with no cocaine.
Okay.
No way, shape, or form.
And
I work like I'm at work right now. I work for my money. That's why I want my money back. Okay.
So if I said that that Officer Esposito recovered 2 small plastic baggies of marijuana in your pants, would that be true?
That was in my pocket. That was on my person.
Okay. And where was your pill bottle?
In my pocket. The marijuana was in the pill bottle with my pills.
Okay. And he said that he saw some kind of small plastic baggie containing a white crumbled powder by the seat, or the floorboard. Did you know anything about that?
No, never seen it.
Okay.
I know nothing about it.
Okay. And is this something that you were told about the next day? Is that what you were talking about?
When I seen the detective, that's when he brought it up. And I told him, I informed him. I said, the dash cam, if they had dash cam or body cam, they'll show everything. Or that car wash camera. I said, one of those 3 cameras will show exactly what happened.
Okay. Did they ever produce those?
No, because the prosecutor she asked, did they have that?
Okay, we're going beyond that, the discovery issue. So
okay,
they didn't have it. It's not in the discovery package. It's not in my discovery package.
Okay, so hold on. I know, Mr. Minkin, don't ask him about discovery issues because that's
okay. Okay.
So
yes.
Here, let me ask a quick question, Mr. Gorey. Can you hear me, Mr. Gorey?
Yes, ma'am. Yes, I can hear you.
Okay, look at me. Look at the camera. When the officers asked the driver for his license, registration, insurance, and he produced all of that, was he still sitting inside the vehicle when he produced all that?
No.
They had already pulled him out the vehicle?
Yes.
Okay, so soon as the vehicle was stopped, the driver was pulled out, or both of you were asked to get out?
He asked the driver to get out. First, he was like, you got your driver? He said, has any of y'all been arrested before? I said yes. And the driver said no. And then they came back. They said he lied. They said, you lied to us. Get out, step out the car. So he stepped out. When he stepped out, that's when he tossed something. And they was right there. They, like I said, all them cameras and lights we was in, everybody seen everything. That's why I was so sure when they got to the preliminary. I just had a mix up in a conflict of interest with my lawyer, my representation, man. I wouldn't be here for this. It wouldn't even. That's what happened. It was just.
I'm going back to the first question.
Okay.
When did they ask him for his license, driver's license, and registration? When was that done?
After he stepped out of after they told him to get out the car.
Okay, and then he produced that, and while he was producing that, where were you?
Sit in the passenger seat still.
Okay, and then after he produced it, what happened after he produced it? Then what happened?
That's after, like I said, when he first got out of the car, that's when he threw whatever he threw. Then he produced his credentials to them. Then one came around to my side. He was standing on my side the whole time, looking down at me. Like I said, when I put the plate of food down, he was right there the whole time. The car is only, my arms take up the whole car, man. It's only so wide.
Okay, Mr.
He told me to get out.
I need you to just answer my question. Once
okay.
the driver produced everything that he was asked to produce,
right?
Then what is the next thing the police did?
Told me to get out the car.
Okay, and what did they do with the driver?
He was just standing out there. They didn't do nothing with him. He was just standing there.
Okay, they didn't hand him a ticket?
He didn't get back in the car, nothing. He was just standing outside by his door the whole time. They didn't search the trunk. They didn't do nothing else.
Okay. All right. Mr. Lincoln, any more questions based on what I've asked?
No.
Okay. All right, Madam Prosecutor?
I don't have any questions, Judge.
Okay. All righty. Argument?
Your Honor, in terms of, for Mr. Gorey, I would argue in this case that basically all this was a traffic stop that involved, they wanted to see his license plate. They came there, they saw the license plate, they checked his license, his registration, proof of insurance, and I don't know whether they gave him a citation or not for having the light not being on his license plate, but after that, they shouldn't have searched anymore. They talked about trying to use the key terms like furtive movements or being nervous. And, there's case law. I mean, they talk about with courts, they give little weight to nervousness in a traffic stop, because I think the officer had said something about that it's an unreliable indicator. And there's a case of United States versus Richardson at 385 Federal 3rd, 625 at 630 to 631. It's a 2004 case. They talk about the fact that when you look at the case that covers like everything, the Rodriguez versus United States, in that particular case, they talk about like when you have a traffic stop, it should end after they go there for the purpose that they're going. They weren't looking for drugs. They didn't have prior drug buys or anything like that. They weren't looking for guns. And so they basically should have stopped the search once they got the driver. It doesn't seem like they didn't put him under arrest. And basically it ended when it's tied to a traffic stop. It should end at that point. And at Rodriguez at 135 Supreme Court at 614, it talks about that. And they talk about the fact about if you have furtive movements, or they talked about him making a movement, and that's why they wanted to do a search. There's law that they talk about with furtive movements. I'm trying to find out what I know. There's I had some case law on it. I got a bunch of things, and I'm trying to find that. If you give me a minute, 1 second. Where did I have that? Hold on. I have it here. I should have had it in a list here. 1 second. Where did I put that? But I do know that they have to have something more than just like a furtive movement. The fact that if you move around in the car, that doesn't mean you necessarily, you all of a sudden get to search the vehicle. Let's see, there was, I know there was a case of People versus Pitts, 40 Mishap 567. It's a 1972 case. That was a case where after pulling over the vehicle, officer observed defendant slipping what appeared to be a small prescription bottle under the passenger seat and searched the vehicle. The defendant conduct was not obviously evasive as to give rise to probable cause that drugs were in the vehicle. Could have been anything that defendant dropped. The officers had to infer that defendant's actions were evasive, that something was in the bottle, and that something was contraband. The officers possessed only a mere suspicion, which does not justify a warrantless search of the vehicle. And then let's see. Hold on one second. That's nervousness. They had in the case of, well, actually in the Pitts cases where they talk about the furtive gestures, it says in that case that the officer acted on defendant's furtive gesture and his negative reply to question that he gave to the officer under the circumstances. In that case, they did not believe defendant's actions were sufficient to create probable cause for a search. So really, the search should have ended. All of anything that was involving Mr. Gorey or seized from Mr. Gorey should be excluded. And once all those items are excluded, then the case should be dismissed based on that. And so I'm asking, based on the facts of this case and the evidentiary hearing, it clearly the only basis for the stop was because they couldn't see the license plate. There's been a number of cases involving and it's just a traffic stop. I don't think it was, it should have gone beyond that, and Mr. Gorey's case should be dismissed.
Or the evidence should be suppressed.
The evidence should be suppressed, and then based on that, there's not enough evidence to go forward, and then it should be dismissed as a fruit of the poisonous tree.
All right, Madam Prosecutor.
Thank you, Judge. So the problem is they pull him over and they ask for his license and registration. Now, anytime you have a lawful traffic stop, cops by Supreme Court precedent and Michigan Court of Appeals precedent since the 70s, they do not need another justification to order you out of the car. That applies not only to the driver, but also to the passenger. They order the driver out of the car, lawful to pursuant to a lawful traffic stop. And the defendant's own testimony today is that the driver threw something at him, at the passenger. And so you have that, you have as the officer testified, the furtive gestures, along with whatever item that was thrown when they were trying to get the license and registration. So this stop never completed. They were in the midst of trying to complete it when the defendant's own actions and the driver's own actions gave cause for them, he steps out of the car and they say, "Can we search you?" And he says, yes. He consented to the search. He admitted to the marijuana. The cocaine is found right under the passenger seat where he was sitting. So, Your Honor, I do not think that the stop was prolonged for any unreasonable amount of time. So I think that the evidence was seized lawfully and that this was a lawful stop. So I would ask that you deny the defendant's motion.
Can I have one response?
What?
Can I
Sure.
have a short response? Only thing I would say is, I know Mr. Gorey says he remembers about throwing something, although the officer did not recall that happening, and they didn't seem to.
The officer did not testify to seeing anything being thrown. So, all right. The court, having read the motions, or read the motion, and having had an evidentiary hearing and having done its own research. First of all, the court heard the testimony of Officer Esposito, who said that on June 29, 2017, he was working with Dearborn Heights PD, and in the area of Michigan and Gully, he was in a marked squad car in a uniform. He said he was alone. He said he saw a white Ford Escort, which had no license plate light. He was asked whether that was an arrestable offense or a ticketable offense. He testified it was a ticketable offense. He said that the car was stopped, and he said that he approached. He said the vehicle pulled over. He approached the car. There were two people in the car. He had contact with the driver. He said that the defendant, Mr. Gorey, was in the passenger seat. He specifically said that he asked the driver for his driver's license. And he testified he was given driver's license. He asked the then driver for his insurance. He was given insurance. He then asked the driver for his registration, and he was given registration. He then said he even ran the driver for warrants, and there were no warrants either. But instead of giving the driver a ticket for a license plate violation, he then claims that he had the driver get out of the car. The court then asked him, why did you have the driver get out of the car when you had received all of the information that you asked for? The driver had tendered his driver's license, his insurance, and his registration. They had also ran him for warrants, and I believe I watched the video, and I think I heard something in the background about they were trying to run a name, and clearly the driver had no warrants, and he said he looked nervous, which the court does not believe is a valid reason. A lot of people look nervous when they're pulled over by the cops. Anyway, he then testifies that he had the driver step out of the car, and when the driver stepped out of the car, he claims that he then saw Mr. Gorey do a furtive gesture, and that was enough to make him then want to search the vehicle. And they go over to search the vehicle, and he claims when they asked Mr. Gorey to get out of the car, he sees the pill, and then the pill makes him want to search further, and he finds marijuana and a bunch of other things. So both counsel are correct in that, well, number one, when the police stop a vehicle, Rodriguez v. United States, the Supreme Court case, does say that that vehicle should not be stopped any longer than it is to deal with the reason for the stop. And in this case, it was a ticketable offense. They do have the right to ask the driver for his license, driver's license, registration, insurance, because if he's driving without any of those things, he can be arrested. I'm not sure about the registration, but I know without the driver's license or insurance, he can be, without the driver's license, he can be arrested. But that wasn't the case. They also ran the warrants, and he didn't have any warrants. Now, Ms. McCrae is correct that the officers can ask individuals to step out of the vehicle if they want to do that. And that's true, they can. The problem comes in, though, whereas the reason the officer gives for having him step out the vehicle is that the driver looked nervous, what the court does not find is a good reason to have him step out of the vehicle. But irrespective of that, once he stepped out of the vehicle, he then says, well, he sees a furtive gesture made by Mr. Gorey. And so he just assumes, based on that furtive gesture, that Mr. Gorey has something. Because then they start to search the entire vehicle. And then they say when they have, he says when Mr. Officer Esposito testified that when he has Mr. Gorey step out, then he sees a pill under his leg. So he doesn't see anything with Mr. Gorey in this furtive gesture. He doesn't see anything in his hand that might look like a butt of a gun or any kind of baggie that might look like any kind of drug. He just says he makes a furtive gesture. Now, in Supreme Court of Michigan, People versus Howell, Howell, 394 Mich 445. Here, the Supreme Court held the police officer who, after having stopped the automobile, observed in plain view a bag bulging with jewelry of a variety and quantity more akin to the result of a theft than the property like to be that of personal belonging. and who also observed some furtive gestures. In this particular case, on these facts, the court held is of the opinion that the officers had probable cause to proceed as they did because the following facts were in evidence. The bag was bulging and the jewelry was in plain view, and the officers saw a variety and quantity of jewelry more akin to the results of a theft than property likely to be personal belongings of the occupant of the automobile. The bag was not the kind that a jewelry salesman would normally use. Then the further behavior observed by the police officers, along with that, and when they asked, "What's the bag?" the response was, "What bag?" So while further behavior by itself does not justify a search, further behavior may be considered as a factor, and as in this case, in combination with other factors that may help establish probable cause. In this particular case, the officers not only had affirmative gestures, and this is 395 Mish 445, 1975. The second half is 445. 231 Northwest 2nd, 650. If we were in a high crime area and there was a furtive gesture made, and maybe we saw the butt of a gun, or maybe we thought we saw some kind of maybe hand-to-hand transaction. Somebody was at the window of the car, and Mr. Goring made a furtive gesture. But the court doesn't see how Mr. Goring leaning to the front, who Mr. Goring is testified was putting a plate of food on the floor, how that ended up being probable cause for them to be pulled out of the vehicle and the vehicle to be searched with nothing more. Because based on the officer's own testimony, he said the only reason that Mr. Gorey was then searched was because he made a furtive gesture. And it wasn't until Mr. Gorey stood up that they then say they saw a peel. They didn't see a peel before Mr. Gorey. He said that once the driver got out, he then saw a furtive gesture being made by Mr. Gorey. And then that made him want to search the car because of the furtive gesture with nothing else prior to that. And then when he had Mr. Gorey get out the car, or whether the other officer did, then they see a peel and supposedly they see some more evidence of some narcotics. But everything that the officer requested of the driver was given to the officer. It was a ticketable offense. A ticket should have been written and handed to the driver, and he should have been sent on his way. The car was held too long. When we asked on, I think the defense asked the officer, "How long did you have this car stopped for this headlight?" He didn't remember. But what we know is they received all the documentation and they ran the driver for warrants. So that took a minute, and he had no warrants. And instead of just handing him a ticket, they then decided to pull him out the car because he says he looks nervous, which the court really does not think is a good reason to have him pull out the car. I understand that the case law can allow officers to ask people to come stand out the car. But, hold on, Mr. Meineke is not in here. I guess he was dropped, and I don't know when he was dropped. Most of it. Mr. Meineke.
Yeah, I don't know.
Have you been?
I've been gone
Right.
since mid, like after you started giving your opinion, and then I got kicked out again.
All right, the court really does not want to have to go through this again, but will briefly.
Can I say something,
No,
please?
no. So, Mr. Meineke, did you hear what I said as far as me going over the testimony of the officer?
I heard part of it at the beginning. You were going over some of it about at the point where he was stopped, that he was stopped because of the light on the license plate, and it was for basically an infraction. And then
Exactly. All right.
that was
it is on the record. The court has made its record, so I'll be brief with that respect. What the court has decided is the stop was legitimate. There was clearly an issue with the license plate light, I'm assuming. But when the officer approached the driver was asked for all of his documentation, which he produced. They even ran the driver for warrants, which he did not have. So clearly that took a little while. And instead of just handing a driver the ticket, The officer Esposito, then testified that he had the driver get out of the vehicle. And as Ms. McCray has indicated, yes, the officers can ask for someone to get out of the vehicle. But when I asked him why he had the driver get out of the vehicle, his response was because the driver looked nervous, which I don't find is a good reason to have the driver to get out of the vehicle, because a lot of people look nervous when they're stopped by the police. But irrespective of that, he had him get out of the vehicle. Still, everything has been tendered to him. He still didn't give him the ticket once he had him get out the vehicle. Then he says upon the driver getting out the vehicle, he sees Mr. Gorey make some type of furtive gesture. There is nothing else besides the furtive gesture. He did not see anybody coming to the window and what may look like a narcotics transaction, where there's no testimony. We're in a high crime area, so maybe Mr. Gorey is putting a gun in the car. He didn't say, I thought Mr. Gorey might be armed, so I had him come out. He just said he made a furtive gesture. And then they decided to have Mr. Gorey get out of the car. It wasn't until Mr. Gorey is getting out of the car that they then say they see a pill on the seat, and that makes them decide to search the car. You have to have probable cause to search the car. What I read into the record is the United States, Supreme Court of Michigan case, People versus Howe, which is 394 Mich 445, 231 Northwest 2nd, 650, 1975, in which the court has held that while furtive gesture behavior by itself does not justify a search, furtive behavior may be considered as a factor, as in this particular case, in which there was a combination of factors. In this particular case, there had been a theft of a jewelry store, although it had happened in a different city a few days before, but they stopped the vehicle, and the officer noticed that there was a bag of jewelry in this vehicle in plain view, mind you, which also something in plain view could create probable cause. And this bag of jewelry did not appear to be jewelry that was purchased. It was of an amount that appeared to be more akin to a theft than personal property. So in combination with this bag of jewelry that appeared to be more akin to a theft, and the fact that when the police asked about the bag, the response was, what bag? And clearly the person could see there was a bag because it was next to that person. And with the furtive gestures, the court then indicated there was probable cause to search the car. I don't find that in this case. The only thing that officer testified to was that Mr. Gorey made a furtive gesture. There's nothing else besides the furtive gesture. Mr. Gorey has testified he made a furtive gesture because he put a plate of food on the floor. The officer didn't testify that there was anything else besides Mr. Gorey leaning forward that made him think that there should be something else. He didn't indicate that he thought Mr. Gorey was armed. He didn't indicate he thought Mr. Gorey was selling drugs. He just said he made a furtive gesture. And because of that, he was asked to get out the car. And then they find a pill, and now they say they have probable cause to search the car. So the court believes, based on the testimony largely of the officer, who received all of the information he asked for at a simple infraction, ran the driver, found out he didn't have warrants, and instead of just tendering a ticket, decided to pull the driver out because the driver looks nervous in his terms. And then because Mr. Gorey leans to the front, he decides to then have Mr. Gorey get out the car. And now we see a pill. Now we have probable cause to search the entire car. I believe it was an unreasonable search and seizure. I don't think he had probable cause to search the vehicle. And the court will suppress the evidence in this case.
Judge, can I
yes.
Can I just make a record?
Sure.
Okay. So Judge, I just wanted to be clear that the officer never testified about seeing a plate. That was the testimony of the defendant. But the people's argument is that taking the furtive gestures and all of that out, that in lieu of Pennsylvania v. Mims, and I'm talking about 434 U.S. 106, 1977, after a lawful traffic stop, which Your Honor has said you believe there was a lawful traffic stop in this case, police don't need any reason, any additional justification to ask a driver or passenger out of the car. And so they did that. And I understand there's, some question about how long there was, but I don't think there was any testimony on this record that shows it was a unreasonably prolonged amount of time. And I know we differ on that, but the officer said that he didn't know. And I don't think there was much of any testimony from the defendant that clarified that. And so I think that officers can be wrong. And I think that taking aside that he said he's nervous, I think that the law is clear that they can ask a driver and a passenger to get out of the car at any time. Once the passenger gets out, there's a pill that is found in plain view. I think at that time that does give the cops probable cause to search the vehicle. Sir, if you could not make any gesture.
I'm sorry. Okay.
Now, Judge.
And the people's argument is noted. And I understand that, but the law is also that nothing beyond what the actual crime is that the car was stopped for, the officer should not be searching unless there is some other evidence they're looking for with respect to what they stopped the car for. This is a ticketable offense. They didn't stop the car and the windows rolled down and they smell marijuana, and thus they have probable cause to search the car. This is a license plate light is out. So why I understand what the people are saying, but you asked for the license, registration, and insurance, and you received that. You even ran the driver, and he had no warrants. So, okay, you asked him to step out of the vehicle. But again, that doesn't give you probable cause to search the car. Now you're saying, well, now when he stepped out. He didn't say everybody was asked to step out. And then I saw the peel, and so now I have probable cause. That wasn't his testimony. He said that once I had the driver out, because his testimony was that he only asked the driver to step out originally. Mr. Gorey has said that they had them both get out, but I'm going by the officer's testimony. He said, I asked the driver to step out, and when the driver stepped out, I saw Mr. Gorey lean forward, and it was a furtive gesture. He didn't originally ask Mr. Gorey to step out based on the officer's testimony. He asked the driver to step out, which, yes, he has the right to do. But then he decided to basically really search that car because of a movement made by Mr. Gorey with nothing else. And that is not probable cause to search a vehicle. He didn't say, I asked that both were asked to step out the car, and upon them stepping out, I saw a peel, and so I have probable cause to search the vehicle. Maybe that might have been a different scenario. He said, I asked the driver to step out. I asked him, why did you have the driver step out after he had tendered all of the documents? He said, because he looked nervous. So he was only talking about the driver, not Mr. Gorey. And then he says, upon the driver stepping out, I saw Mr. Gorey lean forward and make a furtive gesture. So basically, based on that, he decided to search the vehicle. And that is not probable cause to search a vehicle. So the court is going to suppress the evidence. Is there a motion that's going to be made, Mr. Minkin?
Yeah, based on that, the basis of the charges against him, they can't proceed without that evidence. So I'm making a motion to dismiss. I don't think there could possibly get sufficient evidence to go even a question of fact for the jury.
Madam Prosecutor?
Yeah, that's correct.
Okay. Then the court will dismiss the case with prejudice. I mean, the people always have a right to submit whatever they choose to submit. And if the Court of Appeals says that I'm wrong, I will learn something, as I always say. But in this particular case, I was not convinced that there was probable cause to search this vehicle.
Ma'am.
Your Honor, wait, don't say anything, Mr. Gray. I do have
Okay.
one other issue. I was wondering, he had like there was 500 and some odd dollars that they took, and then I don't know what other property. Do I have to bring a separate motion to request that, or can I get can that be released? At least the money, because he
Mr. Meek, first of all, why is this $500 still being held? It had nothing to do with the evidence.
Well, they probably looked at it because they had drugs, and they try to seize everything associated with drugs. Yeah,
okay.
forfeiture.
Mr. Minkin, just submit a motion to the court.
Judge, I think there's actually a pending case on this. Mr. Minkin brought that to my attention today, that there's a pending matter in the civil court. So,
well, Your Honor, I did bring that to their attention, and I was going to tell you that there was a case back. This has been pending. It's back in 2017. It was in front of at that time, Judge Allen, and there's a case number. And my client said they had agreed. He thought to give the money back. It never did. And it's, or at least some of it they had agreed. And it's a case where we couldn't find it. It was case number 17-01-5552 CF. And it actually had a hearing on November 17th of 2017 in Frank Murphy. So I don't know what happened, and it involves $554 in US currency. And it shows people of the state of Michigan, EXREL, and then Kim Elworthy, Wayne County prosecutor versus the currency and Paul Gorey.
I mean, I don't know. Only thing I can tell you, I mean, I have no clue. Mr. Minkin, I guess you can follow up on it and see what you can find out.
Okay.
Otherwise,
Can I tell you what?
Otherwise, you can submit an order to the court for the return of Mr. Minkin's property.
Mr. Gorey, you mean?
I'm sorry, Mr. Gorey's property, and the court will sign it.
and Judge, I just want to be clear, like, I don't remember, of course, I'll contact the police and tell them if whatever evidence they need to, that's not drugs or whatever, to provide back to Mr. Gorey. I just don't remember reading the investigator's report and seeing that they had seized the $500. I'm not saying whether or not it was, but I just want to make that clear that at this point in time, I'm unsure, but I will certainly contact the OIC and say, if there's money, and try and confirm that so he can get it back, if it exists.
Okay. Well, if they took it from him, they should have had when they confiscate things, they are supposed to put it in their report, and they should have had an evidence number attached to it.
I agree, Judge.
So, if they didn't, that's an issue. But anyway, Mr. Minkin, you can do a order and the court will sign it.
Okay, just a separate order for to return the $554?
Yes.
Okay, and do I need to prepare any kind of order for this hearing today, or does the court do that?
I think the clerk, Mr. Mark, has already done that. Is that correct?
Yes.
Sorry.
No, yeah, Mr. Macon, yeah, I've got the paperwork. I will email it to you.
Okay, thank you, Your Honor, and then I'll prepare that. I'll prepare that order. Ms. McRae, I don't know if you find out any further information as far as if we need to do anything else.
I have no idea, no, but I'm gonna get the file back from Heapy and contact the officer in charge and see about the $500, and I'll of course update you and let you know what I find out.
I'd appreciate it because my client can really use it. I mean, he's living from place to place. He only gets disability, and he can use the money. Okay.
All right now.
Okay, thank you, Your Honor.
Everybody
have a good day.
Mr. Gorey, have a good day.
Thank you, Your Honor. Have a good day. Black Lives Matter.
All right. Bye-bye.
Bye-bye.